The Second Amendment states that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
People in Georgia have a very healthy respect for guns. We believe that you should be able to own them. We don't think that you should be forced to own them. But we don't believe that the government should have the right to tell you that you can't own them. I'm in favor of no gun control whatsoever.
Gun rights advocates often consider any regulation of gun ownership as an infringement on their constitutional right. For decades, they have been trying to exercise a line-item veto, erasing the first half of the Second Amendment. They argue that regulations generally are an undue burden on law-abiding citizens. Yet even the National Rifle Association ties the right to the condition of being a law-abiding citizen. Here's what five-time NRA President Charlton Heston said just after the Columbine High School shooting.
As long as there's a Second Amendment, evil can never conquer us. Tyranny in any form can never find footing within a society of law-abiding, armed, ethical people.
Let's examine the phrase law-abiding citizen and how it was understood by the framers of the Constitution when they enshrined the right to keep and bear arms in the Bill of Rights. The American Revolution was the primary reason for including the Second Amendment. The United States would not exist without armed colonists having fought to overthrow British tyranny. After the Revolution, many of the original 13-state constitutions contained provisions regarding the ownership of arms. Gun ownership was never intended to be a universal, unrestricted right. Courts have recognized the conclusion of many scholars that the right to keep and bear arms in those early state constitutions was originally tied to the concept of a virtuous citizenry. Accordingly, governments may disarm unvirtuous persons. This was understood by the framers of the United States Constitution. Law-abiding persons were allowed to keep and bear arms for legal purposes, such as hunting, self-defense, and being available to serve in governmental militias. Keeping and bearing arms was generally prohibited to criminals, incompetents, and insurrectionists. Modern gun control cases echo the framers' understanding that the right is intended for law-abiding persons, and those who are not may be disqualified. Justice Scalia wrote the Supreme Court's 2008 decision in the Heller v. District of Columbia gun control case. He said that constitutional rights are enshrined with a scope they were understood to have when the people adopted them. And whatever else it leaves to future evaluation, it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. Scalia went even further in Heller when he recognized the legitimacy of gun regulations. He said that nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession or carriage of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools.
Emergency crews could be seen tending to the wounded, dressing their wounds.
Coming out with one injured person. He's shot.
Government buildings, or law imposing conditions and qualifications on the commercial sale of arms. The Ninth Circuit echoed Scalia in 2014 when it upheld a San Diego County regulation that concealed carry permit applicants had to demonstrate good moral character in order to qualify. How can you tell if a person is law-abiding without effective criminal background checks? The National Instant Criminal Background Check System, or NICS, is a crucial component in the fight against gun violence. NICS was created to implement the 1993 Brady Handgun Violence Protection Act, which requires background checks for firearm sales and transfers conducted through a licensed dealer.
Bill Plant covered the Reagan administration. He joins us now from the White House. Bill?
Well, Scott, Jim Brady was only press secretary for a few months, but his name lives on here in the White House press briefing room, which 14 years ago was dedicated in his honor. He was a rotund, gregarious Washington insider known as the Bear, possessed of a sharp wit, a love of the political game, and a taste for good food and wine. But just 10 weeks after starting his dream job as Ronald Reagan's White House press secretary, Jim Brady took a bullet to the brain in the assassination attempt on the president. His wounds were so severe that staff members on the scene assumed the worst.
I want to tell all of you here today something that I'm not sure you know. You do know that I'm a member of the NRA, and my position on the right to bear arms is well known. But I want you to know something else, and I'm going to say it in clear, unmistakable language. I support the Brady bill, and I urge the Congress to enact it.
Since the Brady Act took effect, background checks have stopped 3 million ineligible purchasers from obtaining a gun from a federally licensed dealer, according to the Giffords Law Center to Prevent Gun Violence. Justice Scalia emphasized the necessity of adhering to the framers' original understanding in his Heller decision. The framers never envisioned the right to keep and bear arms as a universal, unqualified right. Gun owners had to be law-abiding. The gun lobby will undoubtedly attack any such proposed legislation as unconstitutional.
We're trying to make sure that people keep their rights, because once a right goes away, you never get it back.
Because if you look at the Second Amendment and you look at the Supreme Court's interpretation of the Second Amendment, they're lying if they say that expanded background checks is somehow infringing on anybody's Second Amendment right. It's just not.
We must honor the original understanding of the United States Constitution.